Thank you, Mr Speaker. I rise to speak on behalf of the Green Party on the Canterbury Earthquake Response and Recovery Bill. Mr Speaker, this is an extraordinary piece of legislation. It is an extraordinary time. But the Greens do have some concerns about this legislation. It's worth just briefly recapping the powers that it gives the government. Effectively, it gives the government the powers to suspend, change, extend or modify in any way every piece of legislation bar 5. It can effectively change any legislation by order in council except for the 5 constitutional acts, the Bill of Rights 1688, Constitution Act, the Electoral Act, the Judicature Amendment Act and the New Zealand Bill of Rights. Aside from those 5 acts, every other statute can be changed by order in council. That is, it would empower the ministers to go to the Governor-General seeking to amend or quash or change, modify, extend any provision of any enactment simply by order in council. We have seldom seen a piece of legislation that has such extensive powers and hands over effectively lawmaking to the executive part of government. That's what this does. Because even though there's a list of 22 acts that are identified in this bill that can be changed by government by order in council, the bill also goes on to say that it's not limited to these 22 acts. In fact, the government, the executive, can by order in council amend any act except for the 5 constitutional acts. It is an extraordinary piece of legislation. Now, the Greens are very keen to get on with recovery, but we want recovery to be done well. And so we have a number of suggestions as to how this this bill, the Canterbury Earthquake Response and Recovery Bill, can be amended to make it much more proportionate to the situation we're in and give Cantabrians more of an opportunity to be involved in it. The first amendment that I wish to identify that the Greens will be moving in committee stages is to give that the Recovery Commission that this bill establishes should have a majority of elected Cantabrians on it. This bill proposes a 7-person recovery commission with 4 of those commissioners being appointed by central government. It seems that, to me, that Cantabrians should lead the recovery process. That there should be a majority of elected Cantabrians on the Recovery Commission. That seems to me a very basic requirement. And so the Greens are moving an amendment to get a further 2 elected councillors onto the Recovery Commission so that there is a majority of elected Cantabrians on the Recovery Commission. I asked the Prime Minister a question in the House last week about exactly this issue, whether it would be the people of Canterbury that would lead the recovery. He said they would. And yet when we look at the makeup of the Recovery Commission, 4 out of 7 are appointed by central government. So we'll be moving an amendment to make sure that it is Cantabrians themselves that lead the process. The second amendment we'll be moving is to limit the length of this Act to 6 months. We think the extraordinary powers that are in this Act should be kept on a short leash. So we think that it should only apply to 6 months and that the government can come back after 6 months and seek a notice, move a notice in the House to get a further 6-month extension. That seems reasonable. But given the extraordinary powers in this Act, it seems that it's only right that Parliament keeps the executive on a short leash. And so we say 6 months should be there should be a sunset clause after 6 months. They can come back to this House and seek a further extension for another 6 months through a simple notice of motion. But that way the government is kept, or the executive is kept on a pretty short leash with these incredible powers. The third amendment we'll be moving is that it seemed to us that the government should only be given the power to change through order in council acts that are actually identified in the bill. Currently the government has the power to amend any piece of legislation, any statute on the books by this bill. We think that it should be limited solely to those acts that are actually identified so that people know what are the acts that the government can by fiat change. I mean, this is law by fiat is effectively what this bill establishes. And people of New Zealand have a right to know what laws are going to be amended by fiat by the executive. Furthermore, we think that the LGOIMA, the Local Government Official Information and Meetings Act, should not be in that list. The people of Canterbury and New Zealand have a right to know what their local bodies get up to, and so the government should not be able to amend the Local Government Official Information and Meetings Act through a fiat, through these order in council. We think it's very important that there is transparency around this, so LGOIMA should not be on that list. The fourth amendment we're going to move is to make sure that the Recovery Commission actually is subject to official information requests. Currently it's unclear. There's no statement to say that the Recovery Commission is subject to the Official Information Act or the Local Government Official Information and Meetings Act, and we think it should be made clear that the Recovery Commission is subject to official information. Otherwise, if there's not transparency around this process, then it's hard for ordinary New Zealanders to know what's going on, let alone the Parliament or anyone else. The fifth amendment we'll be moving, Mr Speaker, is around the publishing and tabling of order in councils. Effectively, these order in councils are legislating by fiat. The Executive will have the power to legislate by fiat on any statute except for the 5 constitutional statutes. It seems to us it's critical that when those order in councils are passed, that they are immediately published, that they're put up on a government website so that people know what the law of the land is. It's very hard to know what the law of the land is if there's no way to actually find it out. So we think that as soon as an order in council is passed by the government, it should be published on a government website within 24 hours so that people actually know what the law of the land is. It's hard to follow the law if it's not published somewhere. And so we think that order in councils are effectively legislating by fiat. They should be immediately available to the people of New Zealand and Canterbury so that they can see what the law is. Furthermore, we think that these should be tabled on the next sitting day. Under the Regulations Disallowance Act, they have to be tabled within 16 sitting days, which is a very long period. It's a number of months, in fact. It seems to us that the order in council should be tabled on the very next sitting day so that Parliament can see them. That seems to me just a basic requirement, that the order in council should be given to the Parliament on its next sitting day, and that shouldn't be any trouble given that the government must know what's in those order in councils. The sixth amendment that the Greens will be moving is around Section 6, subsection 3 of the bill, which is basically the section of the bill whereby the government decision-making won't be reviewable by any court around the order in councils. Now, this is a pretty concerning provision. It's fundamental to our constitutional arrangement that the courts can review the government's decision-making processes. Now, we understand that this is a time when we need to make decisions quickly, and we accept that proviso. However, completely throwing out the ability of the courts to have any kind of review of government decision-making processes seems to us a step too far. It is part of the balance of power that the courts have the ability to have a look at what government's done. Clause 6, subclause 3, currently says that the recommendation of a relevant minister, that is a recommendation to the Governor-General to have an order in council, it says that recommendation may not be challenged, reviewed, quashed or called into question by any court. So that is a pretty extraordinary provision. So what we're suggesting as an amendment is to add onto that, add that it can't be called into question by any court, and then add the words, unless a High Court judge determines that fundamental principles of justice will be compromised by not allowing a case to be heard. We think it is critical that there is some kind of judicial oversight of the Executive. If we're going to give the Executive these extraordinary powers to effectively legislate by fiat, then there must be at least some process whereby the courts can review it if the courts, a High Court judge, is of the view that fundamental principles of justice could be compromised by not allowing a case to be heard. So there has to be some kind of mechanism in order to ensure that the courts have some ability to review the Executive if the Executive is acting in a way which is fundamentally against the principles of justice. The Green Party the Green Party believes that the government has good intent in pushing this legislation. We understand where they're coming from. We understand what they're trying to do. However, we think it is a step too far, and that there are a number of ways this legislation can be improved, such as it gets the support of the entire Parliament, so that we can all stand behind it, protecting our Constitution while also rebuilding Christchurch and Canterbury.